Every week, someone walks into work expecting an ordinary day and walks out carrying a cardboard box. Not because they stole from the company, not because they stopped doing their job. Often, it starts with a single sentence that felt completely reasonable to say. They were trying to be honest, trying to set a boundary, trying to ask for help, but somewhere between that conversation and the next performance review, the story changed. Their words became evidence against them. And by the time they realized what had happened, it was already too late. Today, I'm going to walk you through 4 things you should never say at work, why each one can quietly put your job at risk, and the smarter way to protect yourself without sacrificing your professionalism. Hey, I'm Brian, and I spend way too much time thinking about workplace power, employee rights, and the small decisions that end up changing careers. Everything you're about to hear is education based on patterns I see repeatedly in the working world. Every workplace is different, and every situation has its own details. If something serious is unfolding at your job, please speak to an employment attorney in your area. By the end of this video, you'll understand why these 4 phrases feel completely normal to say, and why they often produce outcomes people never saw coming. And if you want practical advice that helps you protect your career before problems start, consider subscribing. That's exactly what this channel is here for. If you're new here and just subscribed, comment your name below. I read every comment and shout out new subscribers in my next video. I do appreciate you joining me on this finance journey. The first phrase is simple. That's not part of my job. And this one breaks my heart because, on the surface, it sounds completely fair. You were hired for a specific role. You have a job description. You already have enough work on your plate. Then your manager asks you to cover another responsibility that wasn't mentioned when you accepted the position. Your instinct is to push back. You aren't trying to be difficult. You're trying to establish a reasonable boundary. Most people believe that's exactly what responsible employees should do. The problem is, that isn't always how your employer hears it. In many workplaces, especially in states with at-will employment, your employer can generally end the employment relationship for almost any lawful reason, as long as it isn't illegal discrimination, retaliation, or another protected reason. That doesn't mean every firing is fair. It means fairness and legality are not always the same thing. Now add another word that appears in countless employee files: insubordination. In plain English, insubordination means refusing a reasonable instruction from your supervisor. Let me say that one more time so it lands. Your sentence may have been about protecting your workload. Their documentation may describe it as refusing direction. Imagine this. It's May. Your manager asks whether you can help with a client presentation while another employee is on vacation. You immediately reply, "That's not part of my job." The conversation ends awkwardly. Nothing seems to happen, but your manager makes a note. A month later, another project comes up. Someone else gets the opportunity because management already believes you're resistant to taking on additional responsibilities. By July, your performance review mentions that you're not flexible and struggle with collaboration. Those phrases begin appearing in writing. Months later, when layoffs arrive or promotions are discussed, that documentation suddenly matters. The original sentence wasn't what cost you. It was the story that sentence allowed someone else to write. The smarter move is surprisingly simple. Instead of saying, "That's not part of my job, try this. I'm happy to take that on. Which of my current priorities would you like me to move so I can give this the attention it deserves?" Notice what changed. You didn't refuse. You asked for direction. You shifted the decision back to your manager, where it belongs. That's a professional conversation instead of a confrontation. You still protect your workload, but you don't accidentally hand someone the opportunity to label you as difficult. That is a very different position to be in. The second phrase sounds even more innocent. "Can we talk off the record?" You probably aren't trying to hide anything. You're trying to be careful. Maybe you're worried about your manager. Maybe another employee crossed a line. Maybe you think something unethical is happening, but you're afraid of becoming the problem. So you look at someone in human resources and quietly ask if the conversation can stay between the two of you. That instinct is completely understandable. Here is what really happens. In most workplaces, there is no such thing as off the record. Human resources is not a courtroom. It is not a therapist's office. And it is usually not protected by confidentiality in the way many employees imagine. This surprises people because human resources often sounds personal, but its primary role is to help the organization manage legal risk, enforce company policies, and address workplace issues. Sometimes those goals align perfectly with helping employees. Sometimes they don't. That doesn't make human resources good or bad. It means you need to understand the structure you're operating inside. Imagine this. You meet with human resources in June. Before explaining your concern, you ask, "Can we keep this off the record?" The representative listens politely. You describe a conflict with your supervisor. Within days, your supervisor is contacted because the company now has an obligation to investigate what was reported. You feel blindsided. You thought you were having a private conversation. The company believed it was responding to a workplace issue. If your concern involves something legally protected, such as discrimination, harassment, retaliation, or potential whistleblower activity, where the law protects employees who report certain illegal conduct, documentation can actually become one of your strongest forms of protection. Let me say that one more time so it lands. When you're raising a serious workplace concern, vague conversations often create confusion. Clear, professional documentation creates a record. The smarter approach sounds like this. I'd like to document a concern regarding what happened on Tuesday. I'm requesting that this report be placed on file, and I'd appreciate confirmation that it has been received. That sentence changes everything. It makes your purpose clear. It creates a timeline, and if the issue later becomes important, you have evidence that you raised it professionally instead of relying on someone's memory. Quiet conversations disappear. Written records are much harder to ignore. That simple shift gives you far more control over your own story. The third phrase is one I hear people defend all the time. "I'm interviewing somewhere else." And honestly, I understand why. You want to be transparent. You want your manager to know you're considering options. You may even believe that honesty will earn respect. Sometimes it does. But here is the hard truth. The moment you say those words, the relationship can change immediately. In many workplaces, you stop being viewed as a long-term investment and start being viewed as a short-term risk. Again, think about at-will employment. In plain English, the company can generally end the relationship for almost any lawful reason. Telling them you're interviewing is usually not a legally protected activity. Let me say that one more time so it lands. Looking for another job is usually legal. Announcing it to your employer is usually not protected. Imagine this. In August, you casually tell your manager, "Just so you know, I've been interviewing." The manager smiles and says they appreciate the honesty. Nothing happens that day. By the next week, a major client account is reassigned. The explanation is that the company wants continuity. A month later, your performance review suddenly contains concerns that were never raised before. Communication, engagement, commitment. Then the hiring market slows down. The other opportunity disappears. Now you're trying to rebuild trust in a workplace that has already started planning for your exit. And yes, in some situations, people have been let go the same afternoon they announced they were interviewing elsewhere. The smarter move is much simpler. Keep your job search private until you have a signed offer letter. Not a verbal promise. Not a recruiter saying they loved you. A signed offer. Until then, your current job is still your income, your benefits, and your leverage. If you need time for interviews, use personal time, vacation time, or approved scheduling flexibility without announcing the purpose. You are not being dishonest. You are separating exploration from resignation. That distinction matters. A professional departure starts when you have another job secured, not when you start browsing for one. Protecting that sequence protects you. The fourth phrase is probably the most human one in this entire video. "I've got a lot going on in my personal life." You're overwhelmed. A parent is sick. A child needs help. Your marriage is struggling. Your mental health is suffering. And you hope that if your employer understands, they'll show compassion. Many managers will. But the problem isn't compassion. The problem is vagueness. When you give a broad personal explanation, you create a statement that can later be interpreted in ways you never intended. Imagine this. In September, you tell your manager, "I've got a lot going on personally." They respond kindly. A few months later, a deadline is missed. Then another. During a performance discussion, someone says, "You mentioned having personal issues, and we've noticed reliability concerns." Suddenly, your attempt to explain a difficult period has become part of the narrative about your performance. That doesn't mean you should suffer in silence. It means you should know when the law provides a better framework than a vague disclosure. For example, the Family and Medical Leave Act, or FMLA, is a federal law that can provide eligible employees with protected leave for certain medical and family situations. The Americans with Disabilities Act, or ADA, can require employers to consider reasonable accommodations for qualifying medical conditions. Notice the difference. I'm dealing with a lot personally is a feeling. I'm requesting information about leave or accommodation options related to a medical or family situation is a protected workplace conversation. Let me say that one more time so it lands. Vague personal disclosures create stories. Specific requests tied to legal rights create protections. The smarter move sounds like this. I'm dealing with a medical or family matter and would like to discuss whether I may qualify for leave or workplace accommodations. You don't need to volunteer every detail of your life. You need to start the correct process. That protects your privacy. It protects your documentation, and it protects the future version of you who may need that record later. Now step back and look at all 4 phrases together. That's not part of my job. Can we talk off the record? I'm interviewing somewhere else. I've got a lot going on in my personal life. Every single one felt reasonable. You were setting a boundary, seeking confidentiality, being honest, asking for understanding. But all 4 had the same hidden effect. They transferred power away from you and gave someone else room to define the story. The pattern is not that employees should never speak. The pattern is that employees should speak with precision. Instead of refusing, ask which priority should move. Instead of asking for off-the-record protection, create a written record. Instead of announcing a job search, wait for a signed offer. Instead of making a vague personal disclosure, ask about leave or accommodation rights. This is not about becoming cold, paranoid, or manipulative. It is about recognizing that work is a structured relationship, and clarity is often safer than emotion. If there's one thing I hope you take from this video, it's this. Protecting yourself at work is not disloyal. It's responsible. Most career damage doesn't come from one dramatic event. It comes from a few ordinary conversations that were handled without realizing how they could be interpreted later. I've made a separate video on the workplace phrases that sound harmless, but can quietly destroy your leverage during a performance review. It's linked below. And if you want practical guidance that helps you keep more control over your career, your documentation, and your options, subscribe. Future you may be very glad you did. Thanks for watching. I'm Brian, and I'll see you in the next one.